Greetings and welcome to this week's edition of Smart Counsel for Lunch. I'm attorney Abigail Poole with the law firm of Samuel, Sayward & Baylor in Dedham, Massachusetts. We concentrate our practice in the areas of estate planning, elder law, probate, and trust administration. Today I wanted to talk to you a little bit about a wonderful client question I got yesterday when I met with some clients. The question was, it's great that we have all these documents in place as part of our estate plan, but how and when do they work together? So I wanted to spend some time today talking a little bit about that. So I look at estate plan documents as puzzle pieces of a larger puzzle. So your estate plan is the puzzle, and then the documents that make up your estate plan are the puzzle pieces. A common type of puzzle is a plan that includes the puzzle pieces of a last will and testament, a healthcare proxy, a power of attorney, and a revocable living trust. So to start off with, a healthcare proxy is a document that appoints individuals called healthcare agents to make healthcare decisions for you while you are incapacitated. That means you're currently alive, but you cannot make those decisions yourself at the time. A power of attorney is similar in that it is a document that appoints somebody called an attorney in fact to make financial decisions for you while you are incapacitated. So the key to these two documents is that they are only able to be utilized while you are alive. When you pass away, those documents are no longer available to be utilized. So if you wanted to, let's say you have somebody appointed as your attorney in fact, you pass away, that person then goes and takes the power of attorney down to the bank, assuming that they can gain access to a bank account that is held in your name. They will be told, no, that's not going to do it. So what happens instead, that is when the last will and testament springs to life as the document that gets utilized. The last will and testament only comes into play after you pass away. And it basically is written instructions to the probate court and to the manager of your estate after you pass away, called the personal representative, to take control of and consolidate, manage, and then administer by distributing out the assets that are in your estate. And so the will tells, again, the probate court and the personal representative what you want to have happen. So the personal representative has to be appointed by the probate court, and once they are, they would have the ability to go to the bank and say, give me access to those funds that I was talking about in my earlier example. The other document that is commonly a part of an estate plan, but not always, because estate plans are very much tailored to the individual needs and wants of each client. But one that is common is called a revocable living trust. And it's a really interesting, flexible puzzle piece because it's an overarching bridge. It can be created during your lifetime and used by you or a backup trustee or manager of any assets in the trust during your lifetime. And then the trust, the revocable living trust, continues to exist after you pass away. And so that's why I consider it this overarching bridge. So it bridges the time from when you're alive to after you pass away. So a really good example of how all these things work together. Let's say you become incapacitated. You're alive, but you are unable to make financial and healthcare decisions for yourself. So, and let's say you end up in a nursing home. So when that happens, you have the healthcare agent under the healthcare proxy making healthcare decisions for you at the nursing home. And then you have the attorney in fact under the power of attorney and your trustee working together to make financial decisions for you, making sure that your home expenses continue to be paid, the mortgage, the utilities, the property taxes, homeowners insurance. All right. What they're also doing is that they are also thinking about, again, the attorney in fact and the trustee are thinking about, are there any other steps that we can take on your behalf that would meet any sort of long-term care planning or estate planning goals now that you are in a nursing home? So does that mean that we apply for public benefits like Medicaid for you? Do we update or change your estate plan in any way that would be, again, beneficial for you or meet other goals that you may have? So that's a really good example of when and how all of these documents might work together at some point. And an important thing to note is that oftentimes, but not always, people have named the same person to serve in all those different roles. So that person might be wearing multiple different, I call baseball caps, essentially. On one hand, they might be making a healthcare decision as your healthcare agent under your healthcare proxy. On the other hand, they also might be making decisions with regards to your finances because they're the attorney in fact and the trustee. You can also have all different people serving in those roles. So ultimately, it's up to you, and that's something that your estate planning attorney would have a conversation with you about if that's the kind of plan that you have in place. So I hope that clarified or explained a little bit about how all the puzzle pieces of your estate plan puzzle would fit together if that's the kind of estate plan that you have. Until next time, take care.